Okay, so first and foremost, good afternoon, and welcome to the Estate Planning Basics webinar. I do appreciate you all being here. My name is Brad Roberts, and I represent CUSO Financial Services. In this estate planning presentation, we'll take a look at some general estate planning concepts and strategies. There's no one-size-fits-all estate plan, and this overview may assist you in thinking about your own estate planning needs and may help you in determining whether you might benefit from working with a financial planning professional like myself. Take a minute and just read through the disclosure here. As I mentioned, we are CUSO Financial, or I represent CUSO Financial Services through Wright-Patt Credit Union. And then below it also shows all of these states that I am currently licensed in. So what is an estate plan? Simply put, it's a map of how you want your personal and financial affairs to be handled in the case of incapacity or death, and the subsequent implementation of strategies that will fulfill those objectives. Who needs an estate plan? Chances are you do. You may think that estate planning is just for the wealthy, but it's not. In fact, an estate plan may actually be more important if you have a smaller estate, because your final expenses will have a much greater impact on your estate, and there's a much greater possibility that your loved ones could suffer from a lack of financial resources. The fact is, without an estate plan, you can't control what happens to your property if you die or become incapacitated. Generally, people create estate plans because they want that control. They also want to make sure that their wishes are clear in order to avoid family disputes. In addition, they care about preserving their property for their loved ones and want to make sure that their loved ones are properly provided for. An estate plan is especially important if your spouse isn't comfortable with financial matters, you have young children who need a guardian, you have an estate that will be impacted by transfer taxes in 2018 on the federal level. That generally means estates that are over 11.2 million. We'll go into that more detail a little later, but also be aware that this amount may be lower on the state level. States impose their own transfer taxes, and each state has a different exemption amount, so I would strongly recommend figuring out what state is for you. Estate planning is also particularly important if you own property in more than one state, you have privacy concerns, or you have other distinct needs, for example, planning for succession of a business. These are estate planning concepts that we'll be looking at today. First and foremost, we'll be talking about planning for incapacity, briefly discussing both healthcare issues and property management issues. Then we're going to talk about planning for death, focusing on wills and probate, tax basics, lifetime gifting, trusts, and the role of life insurance in estate planning. Incapacity describes a condition in which you are legally unable to make your own decisions. We're talking about planning for incapacity first because incapacity could happen to anyone at any time. Think for a moment what might happen if, for example, you were to become a victim of an accident that put you in a coma for several months. How would your doctor know what medical treatments you would want or not want if you can't speak for yourself? How would your personal business be transacted if no one is authorized to sign documents for you? What would happen is this: someone would have to go to the court and get legal permission to do things for you. And that person, who's called a guardian, and is usually a close family member such as a spouse or a child, would have to go back to court every time permission is needed. As you can imagine, this might be quite burdensome on the guardian. Further, without any prepared instructions from you, your guardian might make decisions that would be different from what you would have wanted to happen. Let's talk about healthcare directives first. You can leave instructions about the medical care you would want if conditions were such that you couldn't express your own wishes. There are 3 different ways to do this: with a living will, a durable power of attorney for healthcare, which is referred to as a healthcare proxy in some states, and a do not resuscitate order, or a DNR. A living will is a document that lists the type of medical treatment you would want or not want under particular circumstances. For example, your living will might state that you would not want life support if you fell into a persistent vegetative state. With a living will, you'll have to think about all possible scenarios where you would want a specific action to be taken, and then put your wishes in writing so that the reader will clearly understand them. A durable power of attorney for healthcare, or healthcare proxy, lets one or more family members or other trusted individuals, who are called agents, make medical care decisions for you. Unlike a living will, with this type of healthcare directive, you don't have to envision specific circumstances. You simply grant authority to your agent or your agents to make decisions for you. A do not resuscitate order is used for a different purpose. Let's say that you're in the hospital, lingering and suffering with a terminal illness, and you don't want the hospital staff to take life-saving measures if you suddenly go into cardiac or respiratory arrest. To make sure your wishes are carried out, you may be able to get your doctor to issue a DNR. A DNR is a legal form signed by both you and your doctor that's posted by your bed to give staff members the permission they need to carry out your wishes. Be careful if you're using a DNR. Some states require their own DNR form, and some states require one DNR form if you are using, DNR form if you're in the hospital, and a different DNR form if you're in a nursing home. Now, let's take a look at some property management tools. There are 3 ways you can plan to have your financial affairs taken care of for you in the event you become incapacitated. You can arrange to own property jointly, appoint an agent using a durable power of attorney, or create and put property in a living trust and name someone to take over the management of the trust if something happens to you. Granting joint ownership of your property to another person allows that person to have the same access to the property as you do. If you become incapacitated, your joint owner simply acts instead. For example, if you and your spouse have a joint checking account, each of you can make deposits and write checks. So if you were to go into a coma, your spouse would still be able to make the mortgage payments on time. A durable power of attorney lets you name family members or other trusted individuals to make financial decisions or transact business on your behalf, just like with the durable power of attorney for healthcare. In addition to joint ownership and durable power of attorney, using a living trust is another common strategy. We'll talk in more detail about trusts later, but for now, just know that a living trust can be used in planning for incapacity because someone called a successor trustee can step into your shoes to manage the property in the trust if something should happen to you. All of us make plans that are based on the possibility that a specific event may occur. Many of us carry more than the minimum required amount of auto insurance because we recognize the possibility that financial loss could result from an accident. Since it is 100% certain that each of us is going to die at some point, you might think that everyone would have an estate plan. The fact is, though, that's just not the case. So what happens if you die with no estate plan? If you own property jointly, the property may pass automatically to your joint owner upon your death. If you have an IRA or retirement plan or your own life insurance, funds may pass automatically to your designated beneficiaries when you die. Similarly, property held in a trust may pass automatically to a designated beneficiary. In general, however, property will pass according to state intestacy laws. These laws govern the disposition of property when someone dies without a will or with a will that doesn't account for a portion of his or her estate. So, let's say you die leaving $5,000 in a savings account. Who does that money go to? Without instructions from you, the money would go to the person or people that your state's intestacy laws say it should go to. Intestacy laws vary from state to state, but here you can see a typical pattern of distribution. 50% of property goes to the spouse and 50% of the children. Remember, it may be different in your particular state, so I strongly recommend researching that. The biggest issue with the intestacy is the fact that your actual wishes are irrelevant. Let's assume that you live in a state that has intestacy laws patterned as shown on this slide. Without an estate plan, regardless of your actual wishes, for example, let's say you want all of your property to go to your spouse and none to your children, your estate would be divided between your spouse and your children. There are many potential problems with allowing your property to pass by intestacy. For example, the distribution pattern imposed by your state's intestacy laws could result in disputes among your heirs and higher overall taxes due. Intestacy can be particularly problematic for unmarried couples, since intestacy laws generally will not include an unmarried partner in the distribution of property. There's a very simple way to avoid intestacy, though. You can create a will. Probably the most vital piece of anyone's estate plan. A will is a legal document in which you direct how your property will be dispersed when you die. It also allows you to name an executor who will carry out your wishes, which are stated in your will. In addition, your will lets you name a guardian for your minor children. You can also create a trust in your will. You can use your will to accomplish other estate planning goals as well, such as tax planning. To be valid, your will must be in writing and signed by you. Your signature must also be witnessed, although the number of witnesses required varies from state to state. These requirements are important because if you aren't careful, your will may be invalid. So see an estate planning attorney to take care of this for you and avoid any of the do-it-yourself solutions that you might find on the internet. Now, there is one big consideration to having a will for some people, and that's the fact that wills generally have to go through a process known as probate. We'll take a look at the probate process next. So, as mentioned, most wills have to be probated. The rules vary from state to state, but in some states, smaller states are exempt from probate or qualify for an expedited process. So what does probate entail? Probate starts with someone filing the will with the probate court, which will then oversee the estate settlement process. Usually, the person named as the executor in the will does this. Once the will is filed with the court and validated, the executor can go about the business of settling the estate. This means collecting monies owed to the person who died, such as wages, or paying any outstanding bills, filing final income tax and estate tax returns if necessary, and then distributing the remaining property to the rightful heirs. Usually, everything goes smoothly during the probate process, which typically lasts anywhere from a few months to a year, depending on the size of the estate, as long as the executor does what needs to be done in a timely fashion and there are no family squabbles. Nevertheless, some people may want to avoid this process. Let's take a look why. Before we look at the reasons why you might want to avoid probate, let's review the positive aspects of probate. For most estates, there's usually little reason to avoid probate. The actual time and cost involved are modest and it just doesn't make sense to plan around it. And there are actually a couple of benefits from probate. Because the court supervises the process and you have some assurance that your wishes will be abided by, and if a family squabble should arise, the court can help settle the matter. Further, probate offers some protection against creditors. As part of the probate process, creditors are notified to make their claims against the estate in a timely manner. If they do not, it becomes much more difficult for them to make their claims later on. But for some complex estates, probate can be more burdensome, taking up 2 or more years to complete. This could tie up property that your family may need immediately and also increase the costs that can arise, such as the executor fees, attorney fees, and insurance costs. And if you have real estate in more than one state, for example, if you own a summer home in Maine and a winter home in Florida, your executor will have to file in each state where the property is located. This is referred to as ancillary probate. Additionally, wills and other documents submitted for probate become part of the public record, which may be undesirable if you or your family members have privacy concerns. If any of these issues are a concern to you, an estate plan can be designed to limit the assets that pass through probate or to avoid probate altogether. The major ways property is passed outside of probate are by owning property jointly with rights of survivorship, by ensuring that beneficiary designation forms are completed for those types of assets that allow them, such as IRAs, retirement plans, and life insurance, by putting property in a trust, and by making lifetime gifts. Now let's switch gears a little bit and talk about estate taxes. There are 3 types of federal taxes that may be imposed when property is transferred from one person to another, either during life or at death, referred to collectively as transfer taxes. These taxes are the gift tax, the estate tax, and the generation skipping tax. we're going to discuss transfer taxes on the federal level only, but be aware that the individual states may also impose their own transfer taxes, and they generally affect smaller estates. It's important for you to get more information on the transfer taxes imposed by your particular state. If you, being the donor, transfer property to another person who is a donee during life, the transfer may be subject to the gift tax. The reason there's a gift tax is to prevent individuals from avoiding estate tax by giving all their property away before they die. The gift tax doesn't apply to every lifetime gift, though. For example, in 2018, you can give up to $15,000 to as many individuals as you want, gift tax-free, under the annual gift tax exclusion. By the way, that $15,000 figure is for 2018, but the annual gift tax exclusion is indexed for inflation, so it may change in the future years. In addition, each individual has a lifetime exclusion from all transfers, that's gift and your estate combined, that amount to $11.2 million in 2018. That's the largest exclusion that has ever been allowed in the U.S., in the history of the federal gift and estate tax. When property is transferred at death, it is generally subject to estate tax. This is true whether or not the property goes through probate. For example, even though funds in an IRA pass by virtue of the beneficiary designation, the funds are still potentially subject to estate tax. As with gift tax, there are exceptions to the estate tax. For example, property that you leave to your spouse will generally not be subject to estate tax because there's full deduction allowed for marital transfers. A similar deduction is available for property left to a charity. In addition, as discussed on the previous slide, each individual has a lifetime exclusion from gifts and estate tax combined. That amount is $11,200,000 in 2018. Now, to be clear, there is only one $11,200,000 exclusion that covers both gifts and estates. So any portion of the exclusion you use for gifts will not be available for your estate. There's a new feature of the lifetime exclusion that is potentially very important to married couples, though. The exclusion is portable. That means that any portion of the exclusion that is not used by a deceased spouse can be transferred to the surviving spouse. In prior years, that was not the case, so married couples with larger estates had to do what is referred to as bypass planning, typically using a trust. But for 2011 and later years, such planning will not be necessary for transfer tax purposes, although there are other good reasons to use a bypass trust, but that is more than what we want to discuss today. Suffice it to say that together a married couple can pass along $22,400,000 tax-free as long as the estate of the deceased spouse makes the proper election on the estate tax return. The third piece of the transfer tax system that we need to mention is the generation skipping transfer tax. In the world of estate planning, someone who is more than one generation below you, so for example a grandchild or a great-grandchild, is referred to as a skipped person. If property is transferred either during life or at death to a skip person, then the transfer is subject to generation skipping transfer tax, which is imposed in addition to gift tax or estate tax. The reason there's a generation skipping transfer tax is to prevent individuals from avoiding estate tax on the intermediate or the skipped generation. Because the generation skipping transfer tax is a separate tax, you get a separate exemption. The exemption for generation skipping transfer tax purposes is $11.2 million in 2018. But unlike the gift and estate tax exclusion, the generation skipping transfer tax exemption is not portable. So you would have the 11.2 and your spouse would have the 11.2. If you didn't use it, then your spouse still only has 11.2 million worth of the GST tax. Some key tax figures are adjusted each year for inflation. You can see here how the exclusion and exemptions amounts have changed. The Tax Cuts and the Jobs Act, signed into law in December of 2017, doubled the gift and estate tax exclusion amount and the GST tax exemption to about $11,200,000 in 2018. After 2025, they are scheduled to revert to pre-2018 levels and cut by about one-half. If your estate is larger than the exclusion or exemption, you may want to do some estate planning to minimize the potential impact of transfer taxes. So let's switch gears here and talk a little bit about lifetime gifting. Giving gifts during one's life is a common estate planning strategy that can also serve to minimize transfer taxes. In fact, transferring property to your heirs during your lifetime has certain advantages over waiting until you die. For one thing, when you make lifetime gifts, you have the satisfaction of seeing the recipients enjoy your gifts. For many people, though, gifting is used to minimize transfer taxes. As I mentioned earlier, one way to do this is to take advantage of the annual gift tax exclusion, which lets you give up to $15,000 to as many individuals as you want, gift tax-free, in 2018. And there are several other gift tax exclusions and deductions that you can take advantage of. In addition, when you gift property that is expected to appreciate in value, you remove the future appreciation from your taxable estate. There is one trade-off to lifetime gifting, though. Generally, if you give property during your life, your basis in the property for federal income tax purposes is carried over to the person who receives the gift. So, if you give your $1 million home that you purchased for $50,000 to your brother, your $50,000 basis carries over to your brother. If he sells the house immediately, income tax will be due on the resulting gain. In contrast, if you leave property to your heirs at death, they get a stepped up or stepped down basis in the property equal to the property's fair market value at the time of your death. So, if the home that you purchased for $50,000 is worth $1 million when you die, your heirs get the property with a basis of $1 million. If they then sell the home for $1 million, they pay no federal income tax. Remember that the annual gift tax exclusion lets you give $15,000 to as many individuals as you want, gift tax-free, in 2018. If you and your spouse make gifts together, you can double that amount and give $30,000 to as many individuals as you want. If you're contributing to a child or grandchild Section 529 plan, a type of tax-deferred college savings plan, you can give $75,000 in 2018 gift tax-free, though you will have to report the gift over a period of 5 years. If you and your spouse contribute together, this amount is $150,000. Certain conditions apply in each case. Be aware that if you should die during the 5-year period, a pro rata share of the gift will be included in your estate for estate tax purposes. Also be aware that the $15,000 figure is indexed for inflation, so this amount may rise or fall in the future years. In addition, there's no gift tax imposed on any amounts paid directly to an educational institution for an individual's tuition. There's also no gift tax imposed on any amounts paid directly to a medical care provider for an individual's medical care, including payments for health insurance premiums. If you aren't inclined to make outright gifts, you might consider using a trust. A trust is a common and versatile estate planning tool. We've already seen that a trust can play a role in planning for incapacity and in avoiding probate. In addition, you may want to use a trust as part of an overall strategy to minimize transfer taxes, to have certain property managed by a professional, and to provide for minor children, elderly parents, and other beneficiaries. And certain trusts can be established to protect your assets from future creditors. Most importantly, though, trust can provide a means to administer property on an ongoing basis according to your wishes, allowing you to maintain a degree of control after property is placed in the trust, even after your death. So what is a trust? A trust is a legal entity where someone who's called the grantor arranges with another person who's called the trustee to hold property for the benefit of a third party who's called the beneficiary. The grantor names the beneficiary and trustee and establishes the rules the trustee must follow in a document known as the trust agreement. When you create a trust, you split the ownership of the trust property. Legal ownership goes to the trustee and the beneficial ownership goes to the beneficiary. That means that the trustee is legally responsible for managing the property according to the trust rules, and that the beneficiary receives the financial benefits, such as income, principal, and use of enjoyment, from the trust property. A trust that you create while you're alive is referred to as a living or inter vivos trust. A trust that is created upon your death, for example, under the terms of your will, is referred to as a testamentary trust. If you have the right to change or end the trust anytime you want to, the trust is described as a revocable trust. If the trust cannot be changed or revoked, the trust is described as an irrevocable trust. A revocable trust generally becomes an irrevocable trust when you die, since you're no longer around to make changes or revoke it. While we won't go into great detail about revocable trusts or irrevocable trusts, revocable trusts are commonly used to plan for incapacity and avoid probate. A trust avoids probate because the trust agreement itself determines what happens to the trust property upon your death. Irrevocable trusts, on the other hand, are commonly used for transfer tax planning and creditor protection. Switch gears, and now we're going to talk about life insurance. So life insurance plays a part in almost everyone's estate plan in one way or another. For example, if you otherwise have a small or modest estate, life insurance can be used to actually create an estate. In other words, the life insurance proceeds will be the primary financial resource for your surviving family members, at least until they are able to access other financial resources. Life insurance can also be used to provide liquidity for your estate. That is, the life insurance proceeds will provide the cash your survivors need to pay final expenses, outstanding debts, and taxes. For example, you may have physical assets such as a home, retirement plan, and some other investments that you do not want to be liquidated, but rather left intact for your surviving spouse. And life insurance can play many other roles as well, such as creating a bequest to a charity or providing funds for your child's college education. You need to be aware, however, that the general rule is that life insurance proceeds will be included in your estate for estate tax purposes. Now, recall that in the beginning of this presentation, I made it clear that we're only talking about taxes on the federal level. Here, and in this situation may be different on the state level, recall also that I said we all have $11.2 million is effectively excluded from the estate tax in 2018. So if your total estate includes the proceeds from your life insurance is equal to or less than $11.2 million, you have no worries. But if your total estate is more than $11.2 million, then some of those life insurance proceeds may have to go to pay estate tax. Although the general rule is that life insurance proceeds are included in your estate for estate tax purposes, an estate plan can be structured to exclude life insurance proceeds from your taxable estate. The key issue is the ownership of the life insurance policy. A common strategy to avoid estate tax on life insurance uses a trust to own and hold the life insurance policy. Such a trust is commonly referred to as an irrevocable life insurance trust, or ILIT. If the irrevocable life insurance trust owns the life insurance policy, the proceeds of the policy will not be included in your estate for estate tax purposes. However, this is only true if the strategy is correctly implemented. Ultimately, you'll need to work with an experienced estate planning attorney if this strategy is of interest to you. But I can give you a quick basic idea of how an irrevocable life insurance trust can work. You create an irrevocable trust, name someone as the trustee, and name beneficiaries. The trustee then buys a new life insurance policy on your life. The irrevocable life insurance trust then owns the policy. You make cash gifts to the irrevocable life insurance trust. The trustee notifies the beneficiaries as you make the cash gift. The beneficiaries have a limited window of time during which they can have a technical right to withdraw your cash gift, but they don't, since withdrawing the gifts would defeat the purpose of the trust. And then as withdrawal period elapses, the trustee uses the cash gifts to pay the premiums on the policy of the insurance company. At your death, the irrevocable life insurance trust receives the proceeds of the life insurance policy. If properly implemented, no estate tax is due on the life insurance proceeds, and the funds are distributed according to the terms of the trust. The beneficiary of the irrevocable life insurance trust receives funds free from estate tax. Like most trusts, irrevocable life insurance trusts are a more advanced estate planning strategy, and I've just attempted to give you a very basic understanding of how they might apply to your particular situation. If you are interested in learning more, I'd be happy to provide you with additional information. So, as we wrap up, take a moment to ask yourself these questions. First and foremost, do you have a plan in place for the incapacity? Do you have a will? If the answer to either question is no, there's really no time to waste. You need to address these issues as soon as possible. Ask yourself as well if transfer taxes are an issue for you. If you died today, would your total estate, including your home and life insurance, exceed the federal exclusion of $11.2 million or your state exemption limit, which may be less? Finally, even if you have an estate plan, does it reflect your current wishes and circumstances? Small steps can enhance your financial life one day at a time.